Well, she mailed one, but that's another story. But Cindy and I have 6 children, all boys except for 4. And we are now expecting our 9th grandchild. So we're pleased. 7 granddaughters, 2 grandsons. So a lot of women in our family, and we just love it. And the grandkids, I tell folks, that's the reward for not drowning them when they were teenagers, right? So we just love being grandparents. Let me make some introductions here. Barry Peterson, right here, your own Barry Peterson, who is the chairman of the Idaho Republican Party, does a great job. Barbara Steele is here, and Barbara is your county clerk. Barbara, stand up and say hi. Thanks for being here, Barbara. You've already heard from these 2 gentlemen, but they do marvelous work representing you in Boise. Pete Nielsen, your representative. Pete. Yeah, Pete. Pete's wife Connie is here. Connie's sitting there. Connie, welcome. Senator Burt Brackett and his wife Paula. Senator. We also have a good friend of ours, but maybe somebody new to you, Senator Russ Fulcher and his wife Kara are here. Senator? Russ serves in Senate leadership, and it's great to have him here. It's good for you to get to know him. He serves Idaho and his constituents there in Ada County very, very well. Our State Controller, Brandon Wolf, is here. Brandon, thanks for being here. I hope I haven't missed any of the elected folks at the local or state level. I think we got everyone. If I did miss anyone, raise your hand. This is your chance. Yes, ma'am. City Council. Stand up. I don't recall your name.
I can't stand up.
Okay.
Elaine Isaac, and this is my husband, Ron, who knows about being a spouse.
Well, thank you for being here. We are now going to have our keynote speaker, and that is Doug Traubel. You all know Doug. He has been involved here and in the community and in the party for some time. He has a very interesting topic. My wife and I were talking about this just a while ago, about the whole concept and the whole understanding or the misunderstanding that people have about our elected sheriffs and the role that they should play and can play. And Doug's that's his keynote presentation. And we'll hear from him, and then afterwards we're going to have another special musical number by the McWhite sisters. And then we will have an open mic session where you'll get to hear from some of the candidates that are here. So let's welcome Doug to the podium and thank him for his giving us his time.
Thank you. How many men here have been married for over 15 years? Just a moment ago I went to reach for my glasses, and instead, I don't know if you guys can brag about this or not, finding love notes in your lunchbox or your blazer, sealed with a kiss from my wife. So I thought I'd just brag in front of her. She's right here, Janelle. Beautiful blonde right here. And she's always good about words of encouragement at the right time. I'm sure I'm supposed to find this in the car and read it to myself, but hope to be a blessing to all of you. Disclaimer: the views expressed by Doug Traubel are not necessarily those of his wife or children. P.S. Don't forget the milk, 1%. Before I can share tonight's topic, that of the restoration of a constitutional sheriff, I must provide some context. Over my 27 years as a peace officer, I have had a front row seat watching the growth of all levels of government, but in particular, the federal government. Correspondingly, I've seen the citizens shrink. The pace of growth has been incremental over much of my career, but since 9/11 it has accelerated. The size of the federal government today and the reach of its tentacles has so eclipsed the states that one would have to look in a textbook to know it's the states that gave birth to the federal government and not the other way around. Power is supposed to flow up from the people. Instead, we find ourselves covered by the weight of an intricate web of federal regulations and armed bureaucrats that justify their existence under the unobjectionable sounding banner of public safety. Many of these bureaucrats call themselves law enforcement, and no doubt feel noble carrying out their duty. But a lot of abuse can come under the banner public safety. They care. They care so much about our safety that the USDA made armed raids of family farms for the crime of selling raw milk and organic vegetables. It is wise to question the motives and constitutionality of this level of intrusion in our lives. Government that seeks to remove all risks removes all rewards of liberty. The safety of the nanny state is tyranny. They cared so much in the aftermath of Hurricane Katrina in 2005 that FEMA, along with the help of duped local law enforcement, set a dangerous, unconstitutional precedent. Abandoning their oaths, they disarmed law-abiding citizens, leaving them vulnerable to roaming bands of violent predators. The feds are in our backyards more and more. Much of the power and influence the feds enjoy over the states has come about through the repeated misuse of the Commerce Clause. The original intent of the Commerce Clause on the states was simply to function as a constraint upon interference with interstate commerce. But through Supreme Court decisions, the Commerce Clause has become the primary source for regulatory expansion over the states, undoing the framers' original structure of limited and delegated powers. Consequently, the federal government has jumped its constitutional guardrails and is drunk on power it was never intended to drink. Through intimidation, ignorance, and fear of losing federal funds, states comply with regulation, surrendering the constitutional principle of balanced powers known as dual sovereignty, where each part, federal and state, is sometimes superior and sometimes subordinate to the other. You see, states do not have rights. Only citizens have rights. States have powers. And when states do not assert the powers reserved for them under the 10th Amendment against federal overreach, the citizen shrinks. As the term suggests, dual sovereignty has two parts, but one part is sitting out. State sovereignty must be asserted for the proper balance of power between states and the federal government to be restored. To restore means to return to a former state, what was. This is what is needed in the United States, a restoration, a return of balanced powers, and with it, a return to the form of government we once had. James Madison said, "A healthy balance of power between the states and the federal government will reduce the risk of tyranny and abuse from either front." Friends, we've lost that balance. Dennis Prager said, "The bigger the government, the smaller the citizen." We are there. Thomas Jefferson warned, "When all government shall be drawn to Washington as the center of power, it will render powerless the checks provided and will become as venal and oppressive as the government from which we separated." Venal, not a common word, means corrupt, as corrupt and oppressive as the government from which we separated. If we're not there, we are awfully close. When I consider the web of regulations and regulatory agencies spun over the states, one of the grievances in the Declaration of Independence resonates. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. We are there. TSA alone has grown from 16,000 agents to 51,000 agents in 10 years. They've grown beyond airports and have done 9,300 unannounced checkpoints. Then there's HUD, U.S. Forest Service, USDA, FDA, FCC, Department of Education, DHS, EPA, EEOC, OSHA, BLM, DEA, BATF, etc., etc. None of them fall within the enumerated powers granted in the Constitution, but they lord over us. Between the years 2000 and 2010, 800,000 people were sentenced for federal crimes. Now, I'm not saying that they were all over the top, but here's just one example that illustrates why local control of law enforcement is so important. In 1997, racing legend Bobby Unser and his friend Robert Gayton were snowmobiling in New Mexico when they were caught in a blizzard. They spent 2 nights in the wilderness and survived hypothermia. When their health improved, it was time to go find the snowmobiles. On the way, they came across a deputy sheriff who advised them that the area they're going to explore contains some restricted wildlife area that they should check in with the U.S. Forest Service. Well, Unser, being a law-abiding citizen, did just as the deputy suggested. The Forest Service brought out maps and pored over them to help Unser and his friend determine where their snowmobiles could be. Then the Forest Service worker issued a citation to Unser for snowmobiling in a restricted wilderness area, a conclusion he drew from their conversation about where the snowmobiles could be or might have traveled. Ultimately, the snowmobiles were located outside of the restricted wilderness area. Unser explained to the court that if he had been in the restricted area, he had no choice given the blizzard. But there was no room for discretion, there was no intent established, and no evidence. Unser faced the maximum penalty of $5,000 and 6 months in prison. Unser was found guilty by a federal judge who told him that he had to prove he was innocent. What happened to the presumption of innocence? Unser appealed and lost. He spent over $300,000 fighting the charge. It's estimated that the federal government spent $1 million. In the end, Unser was fined $75 and has a criminal record. Many so-called federal crimes like this are just regulatory violations. The standard of proof is often lower, and the fines and penalties are higher than state crimes. The average defense attorney charges $300 an hour. At that rate, how much justice can you afford when snared by a bureaucratic robot playing cop who justifies his existence to someone in D.C.? As Unser learned, it is cheaper to plead guilty and just pay the fine. Incredibly, the United States Constitution mentions only 3 federal crimes: treason, piracy, and counterfeiting. But today, there are literally more federal laws and regulations than can be counted. There are so many that it seems we can be in violation of something at any given moment. Many of these crimes are duplication of state laws. Some are the product of politicians grandstanding on issues and putting their name to legislation, while others, I believe, come into law so that the feds can step into local affairs and persecute rather than prosecute when they disagree with what a local jury or prosecutor did. Now, as you know, the 10th Amendment of the Bill of Rights reaffirmed that any power not explicitly granted to the federal government was explicitly withheld from the federal government. Despite this, the federal government has become what Professor Edward Earle of UC San Bernardino describes as an administrative state. This is a system where administration and regulation replace politics as the ordinary means of making policy. The administrative state elevates the welfare of the collective over the rights and liberties of individuals. The overreach of the administrative state is seldom challenged by state governments because they depend on federal money. Sometimes state officials cite the supremacy clause to their constituents as political cover for standing down to overreach. The supremacy clause is not a federal trump card over the states. The misinformation over the meaning and scope of the supremacy clause has intoxicated federal bureaucrats with an attitude that they have absolute power over the states and has conditioned the people to believe the same when they do not see their state government stand up jealously to federal overreach. Jealousy is the fear of losing something you love to someone else. Jealousy is the tenor we need in our elected representatives when it comes to Idaho state sovereignty and individual liberty. I see that tenor in Pete Nielsen. We need more statesmen like Pete and less compromising politicians that use our freedom as a bargaining chip for federal dollars or personal gain. Alexander Hamilton made clear, when the U.S. law is not pursuant to its constitutional, limited, and delegated powers, it would be merely a usurpation and will deserve to be treated as such. Certainly, the founders agreed that a supreme law was required for any proper government to function, but the federal government would be limited in its scope of supremacy to only the laws pursuant to the Constitution. This brings me back to dual sovereignty. How do we begin to challenge overreach and restore the balance of power? How do we move to reclaim liberty, the theme of this evening's banquet? There is an office uniquely suited to defend individual liberty from federal and state overreach, the county sheriff. When you think of the office of sheriff, you may not realize how uniquely suited it is to defend individual liberty and help restore state power. The sheriff is truly unique, one of a kind, unlike anything else. The sheriff is the only elected peace officer in the country. The sheriff does not answer to a bureaucrat in Washington, D.C., nor to the president, nor the governor, nor county commissioners, nor a judge. The sheriff answers to the people. And he has the relative autonomy to exercise moral agency over how laws are enforced. The sheriff is a constitutional officer. He must exist. Police departments can fold, but the sheriff will always be. By design, the sheriff is elected and close to the people, chosen to protect them from criminals of all stripes, including overreaching federal or state government. The sheriff is the people's guardian. The Supreme Court, in a 1994 case, Mack Prince versus U.S., reaffirmed the sheriff is the chief law enforcement officer of the county and in this country. This begs the question, why do we so seldom see sheriffs assert their authority against federal overreach or challenge federal abdication of a delegated duty like securing the border? Answer, the office of sheriff has been compromised by ignorance and by dependence on federal money, mostly in the form of grants and gifts. The good news. There's a movement called the Restoration of Constitutional Sheriff. Its aim is to remove the influences that compromise the office and replace it with conviction to the oath of office. Tied to this movement is the Constitutional Sheriffs and Peace Officers Association, or CSPOA. Their mission to equip sheriffs, peace officers, and public officials with the necessary information and public support to carry out their duties in accordance with their oaths of office. There are 3,100 sheriffs in the United States. Of them, 479 are now members of the CSPOA. In addition, there are county commissioners that have joined and are backing their sheriffs. It would seem that these 479 plus elected officials have asked an important question. Of what value is your oath when you take it and then yield to the very forces and fears it was intended to withstand? So what does it look like when sheriffs are led by a conviction to their oath? In Wyoming, sheriffs require that feds check in before making arrests, serving papers, or confiscating property. This policy came about after INS, now known as ICE, raided the Castaneda family's home. The problem? The Castanedas were American citizens. This Wyoming sheriff's policy will save lives and protect rights by providing much-needed sheriff oversight over overzealous federal law enforcement. Other examples of sheriffs standing up: in New York and Colorado, sheriffs refuse to enforce state gun control laws that are unconstitutional on their face. New Mexico sheriffs threaten to arrest feds who move to confiscate guns. Sheriff Johnny Brown of Ellis County, Texas, said he would resist any effort by the feds to confiscate firearms in his county. Sheriff Brad Rogers of Elkhart, Indiana, told the FDA he would arrest their agents for trespass if they entered an Amish farmer's land to inspect without a search warrant. The feds threatened to arrest the sheriff. The sheriff didn't flinch. The feds slipped away, dropping the issue. Sheriff Joe Baca in Sierra County, California, told his county commissioners he would not enforce BLM road closures in the National Forest. Sheriff Baca understands that sheriffs cannot be pressed into service to enforce federal regulations. Sheriff Gil Gilbertson of Josephine County, Oregon, told the U.S. Forest Service and BLM he would access any closed road he deems necessary to perform his many and varied duties as the chief law enforcement officer in the county. And furthermore, he would not recognize any closures that are not coordinated through him and articulated with sound reasoning. Sheriffs are standing up. Momentum is building to defend state power and individual liberty. Now, 68% of Elmore County is federal land. How does this affect the sheriff's authority to interpose his office between federal overreach and the people's rights on public land? I'll answer this by sharing a small part of an argument being made to parallel circumstances by Sheriff Gilbertson of Josephine County, Oregon, whose county is also 68% federal land. The entire argument can be found on the web. It's 13 pages long. It's called Unraveling Federal Jurisdiction Within a State. Sheriff Gilbertson starts off with the fact that it is well established that the sheriff is the chief law enforcement officer in the county. This, he says, includes on lands managed by the federal government, notwithstanding areas of exclusive control, like military bases and post offices and the like, as mentioned in the Constitution under Article 3, Section 7. Furthermore, according to what is commonly referred to as the 1957 Eisenhower Report, Sheriff Gilbertson points out that there are 4 categories of jurisdiction over federal lands. Elmore County, like Josephine County, falls under Category 4, proprietorial jurisdiction. This means that the state has all authority. A county is a subdivision of the state, each with an elected chief law enforcement officer, a sheriff. The federal government has some right or title over an area, but no measure of the state's authority. The federal government operates in a governmental rather than proprietary capacity. In addition, Sheriff Gilbertson points out there are federal court cases that reject the empowering readings of the Commerce Clause that brought us to the point of a lording, armed, administrative state. I will add, this includes even Chief Justice Roberts' unpopular opinion on the individual mandate of Obamacare, where, interestingly, he too rejected the Commerce Clause as the expected authoritative source. Chief Gilbertson and other sheriffs and legal scholars are making sound, well-researched arguments that substantively rebuke federal overreach. These arguments are built on the Constitution, case law, historic documents, all juxtaposed to the government's own bureaucratic policies. One such source is a congressional report dated October 23, 2000. A land dispute between the U.S. Forest Service and Elko County, Nevada, was resolved in part by referring to a 1907 Supreme Court case, Kansas versus Colorado, where it was ruled that the U.S. Forest Service had no general grant of law enforcement authority within a sovereign state unless designated as such by state authority. Following this argument, who is the chief law enforcement officer in each of the 44 political subdivisions of Idaho that can grant or revoke such police power to the feds? The county sheriff. This is a snapshot of a more compelling argument that Sheriff Gilbertson and others in the Constitutional Sheriff Police Officers Association are making, that the feds have no constitutional basis of authority for law enforcement powers in the county. The federal government's response has been silent for the most part. They have offered no counter-argument. It seems as though it finds itself in the untenable position of defending its practice of overreach against sobering constitutional realities and historical court precedents that favor dual sovereignty over federal tyranny. To their dismay, constitutional sheriffs are not going away. The numbers are growing, and the argument is getting stronger and louder. Now, let me be clear. This is not talk of revolution. The revolution already happened. It happened incrementally over the last 50 years at least, and the citizen lost. What I'm sharing tonight is one of the avenues to restoration. If we still live in a constitutional republic, if the rule of law still matters, there can be only one response to a legitimate challenge by a state to overreach: a shrinking federal footprint and citizens that stand taller. Otherwise, we are living under some other form of centralized government hidden behind the facade of a caring, bloated administrative state where regulations penned by federal bureaucrats combined with presidential executive orders have replaced the Constitution as the supreme law of the land. The objective of the Constitutional Sheriffs Police Officers Association is twofold. First, encourage sheriffs to honor their oaths to defend two constitutions, one federal and one state. Second, bring the number of elected sheriff members high enough so that they can act in unison and declare to the federal government that the people have had enough of their overreach and are reclaiming liberty. Obviously, there are consequences to standing up to federal overreach, such as defunding and the potential of lengthy and costly legal battles. But for the right reason, at the right time, and in the right measure, sheriffs are in the unique position to stand up as the guardian of the people and the Constitution. The alternative to standing up is for states to continue standing down and submit to the federal government's insatiable appetite for yet more power it was not delegated, thereby turning citizens to subjects. Whether to submit or restore, the decision is ours to make now. Action cannot be left for the next generation. They have no frame of reference for what has been stolen from them. We have a duty to posterity. May God bless the Republic.
That was fantastic and very thought-provoking, and I hope we all recognize that we're going to hear a lot of words tonight, maybe none more important than what we just heard. And so thank you again, Doug. That was marvelous. Thank you. We're now going to have the opportunity to hear again from the McWhite sisters, and while they make their way up here, just remember or remind you about